actually made a resolution that each and every parliament should come up with a caucus, SRHR caucus, so that this can be deliberated on with champions. So you are many steps away, much further from us. We are still starting. Thumbs up for you. Now I said, I think it's worth emulating what the Honorable MP of Zambia and his colleagues did in coming up with the caucus and the strides they took to change certain restrictive policies on SRHR. Now, in Zimbabwe here, generally, when you want to talk about SRHR, people think that you are talking about sex. We have to demystify that concept so that people or our people or especially elders understand what really we mean when we say SRHR or access to health services, because this is where everything ends. The minute you want to isolate it, I listened to somebody who was saying health services, if you try to subtract and just take SRHR from the health services, they start asking, why are you isolating this one? What's so special about it? And the minute you say, and vulnerable groups, you know what now they think. So it's a very sensitive issue, and it has to be attacked with care. Strategies to convince the traditional leaders, to convince even the parents. Some of us are the parents who make a step forward, then another step, no. We rotate and take a step backwards. That's why we are always here. This is why we are always here, with the same resolutions, not solved. What is the way forward? I think the way forward, if I can partake from what the Honorable did, I think we need something like a caucus or something like a committee, which actually helps and assists from what the EVOS is doing here, another step, so that they help the members of parliament and the SADC officers whom we have at the parliament, so that we can have these issues almost every time when we go into parliament, so that whenever we find a chance, like questions with notices, questions without notice, questions, and all those questions with notice, motions, and maybe we can even be advised, we can even advise you that this concept now needs petitions, so that we can work and push every time. Then from here, we say, what exactly are we pushing? We then give each other that task, so that each and every country, the 5 or 6 of us, we go and push the same. Then we sit, even if we are not doing the actual regional thing, we communicate and say, where are we? So that you give each other ideas and techniques, so that we can do something better, instead of being on the same step. Even a child, when it is growing, she or he covers some milestones, day and a day, and she stands day and a day, she walks day and a day, she runs. Let's day and jump. Thank you.
Okay, so she will be the last one.
Okay. Good afternoon once more.
Afternoon.
Okay, my question goes to Honorable Msanje. You earlier shared that there's an advocacy strategy that was developed. My question then becomes, with the current funding gaps, what is your plan in terms of implementation? Is there a budget, specific budget that has been allocated towards the implementation? And also there's need for capacity and collaboration with partners to ensure that there's full implementation of the advocacy strategy. What are you doing about it, and what is the plan in terms of implementation, so that it is just not written policy, but fully implemented and is on the ground? I submit.
Okay, thank you so much for the questions and comments. I will now hand over the opportunity to our panelists to respond to all the questions. We'll start with Honorable.
All right, thank you so much, and thank you for the various interventions from
many of you on what we have presented with my colleagues. I'll answer some of those that relate to myself, and then my colleagues will continue to complement. And I think starting with our Honorable Member of Parliament from Zimbabwe, thank you so much for bringing out, I think that's the regional consensus, to have these caucuses that help or complement the actions of civil society, because civil society on their own may not manage to tackle some of these issues, but as the parliamentarians, we've got that opportunity of influence, which gives us the opportunity to be able to open doors everywhere. Like I think somebody asked about how do you bring these permanent secretaries and the like. So we use that opportunity of influence where we are able to be able to summon them. And so, just like in Zimbabwe, I think in Zambia also, laws are made from 3 points: that one can petition Parliament on a particular issue, and the Speaker will evaluate and then put a select committee to deal with that issue, and it will get views from the public, and then it will come to the House for lawmaking. Or a motion can be moved by a member of Parliament on a specific issue after a very good research, or one can put a parliamentary question like you have said, which can then be responded, and once it goes into the answered, which is the record, then it becomes something that must be followed through the post-legislative follow-up by government. And the final one is the commonest is where a ministry brings a bill to Parliament. And that's the commonest which we see in almost all parliaments, because we see most laws coming from the bills, a few from parliamentary questions, and a few from motions, and very, very few from petitions. So citizens do not seem to understand that they have got the opportunity to petition Parliament on particular laws. And I think from 2021 in Zambia, when I went to Parliament, to date, we have only had one petition, where somebody petitioned a youth actually petitioned the Youth Act then, which houses some youth legislation matters, and so that is the situation where citizens are not utilizing that. So I think, like you have said, going forward, we definitely need to demystify SRHR as a health rights. And this is what we have been doing at the Parliament of Zambia. We've been doing a lot of capacity building of the members of Parliament so that we can actually make them, first of all, understand these things. And we built a core group of about 12 to 15 champions. So those 12 to 15 champions work with me and a few others on every issue. And then we have been building capacity on everybody else so that we can be aligned and be able to support things countrywide, because we've got 156 constituencies. If we get every member of Parliament to appreciate this, then we know we'll be reaching many other people, because we do address these issues in our constituencies. But we also know the opposition in Parliament. We've got a few who oppose these subjects, and we have actually sometimes targeted to conversate with them. What is important is to bring dialogue and a conversation on these matters, so that you can bring, they can bring their views and we can bring our views. And what exactly the Honorable mentioned there, some of the people mistake our subject to other things, and we have to literally take them, workshop them, in our discussions for them to understand what we are doing. Rennie, you have asked about advocacy strategies and the governing cards and the like. What we have done, of course, to officially to the Ministry of Health budget, the budget cuts of those have been covered for some things, a number of things, but to our work as parliamentarians, we continue to lobby and work with you, civil society especially, to support our work. And the fact that we have already got champions and have built capacity in a number of MPs, it is much easier for us to move in whenever we are required to be able to take these things forward, because we don't need to put in a lot of resources, but you know, our work involves a lot of consultation, and as parliamentarians, we invest more in talking. You know, we invest more in talking. So what we want is for you, when you have your activities, to bring us on board, like Hivos has done here. Bring us on board, and then we'll be able to deliver our message and demonstrate that it is possible to bring about that necessary change, as long as we're able to sit on the same table. And that's why even the Parliament of Zambia developed a strategy to take Parliament to the people, so much that a number of things can now be, parliamentarians can be accessible to the people, and it becomes easier to discuss things unlike before. Professor Bizo, thank you for your commendation. And the issue of which you have mentioned on termination of pregnancy is a very, very big issue, and I really sympathize with the death of the young lady you talked about. That's very, very touching. And this is something which we also tackling to try and amend the Abortion Act, which goes back to 1972, I think, in Zambia, because it is one of those archaic laws that is not helping the situation, like you mentioned, where information and services are delayed because of the 3-line doctor requirement, which definitely you will not easily find in almost 70 to 80% of the health facilities in the country. And so we really need to take this information out there so that our people can be saved. And it's actually, I find that to have been quite negligent of our health workers. They should have arrested that case before reaching that level of one actually going to theater for a delayed period. I like the information you have provided on the WHO study, and I think it will be good for you to share this report to us so that we can actually also study it, and maybe we can actually discuss it even as a caucus, so we can make summary points that we share to parliamentarians, and that information can help us to take things forward. There was a question about, from my brother there, about me being a politician and what I say to my constituents. Indeed, it can be a dangerous path for a politician to support certain things, but lucky enough for me, I've stood firm, even as late as on Sunday, because I only traveled yesterday morning into Lusaka. Even as late as Sunday, I was talking about these things to crowds in my constituents and the neighboring constituents, Dundumwezi, where there was a traditional ceremony. When I get an opportunity to speak, I talk about issues of age of consent. I talk about the Child Code Act. I talk about many other laws we have come up with from Parliament, and I raise these issues. And I found that there has been overwhelming support, especially from the women. The women seem to respond much more positively whenever I'm speaking about these things than the men. Maybe the men don't want to show it, or maybe they are afraid because they are the ones most who are being taken to the police for defilement and related matters. But I've talked about them openly, and I've shown examples, because we have retrieved some young girls from early child marriages, and we have also taken some people to court for defilement and the like. And so people who have been arrested, we have used them as an example to this. And so I think what is important is if you are consistent in your messaging, then it becomes easier. You must show the progress that is being made. So I've demonstrated progress that with these laws, this is the progress we have made as a country. And then I brought the fear to say, if we don't have these laws, these are the consequences. The 17,000 girls who are pregnant is the consequence. The HIV and the burden on the health sector in case of one getting infected, a sick person, and everybody has seen that impact in their homes because you know what it means to look after the sick people, to feed them, and all that. And we have talked about we talked about the impact on the education and all that. And so, and when we have talked about the way forward, that these matters must be dealt with by everybody in our communities. We have challenged the headmen to implement these laws. Lucky enough, working with the First Lady, Mrs. Mutinta Echilema, she's championing early child marriage and these issues. So I've said, this is what the First Lady is also saying. She's also supporting these matters. So let's take them forward. The President was magnanimous enough to sign these laws immediately. And so the fact that the President signed, it is us now to implement them. And you headmen are at the center of this to ensure that in your village, nobody violates these laws, and you are all keeping everybody safe, because it's your responsibility to look after people as a headman. So those are some of the actions we have taken. I think the last few points were how do you ensure laws align to reality? I think it's that process which I mentioned about if coming up with the law, which involves the process of a committee having a public hearing. There is always that window of public hearing to end law. So if you hear in your country that this law is being debated in Parliament, you just go and inquire, you'll be given an opportunity to present. And so, because there is even a day which is allocated to the general public. And unfortunately, that day is rarely used by citizens. Very, very few citizens come to appear before our committees when we are doing the day which is allocated to the public. It's the days when we have said, okay, let heroes come, heroes will come. But the day we say today is public day, you find maybe one. And oftentimes it's another parliamentarian who has got views on that matter. So we from those views which you bring as citizens, that's where we get the reality. We get the reality from you citizens, and hence we make laws that align with the reality and what you the citizens tell us. And support to persons with disabilities who face violation. This is a very important area. Apparently, like I said in the morning, I also chair the Disability Caucus, and what we have been doing there is to test the laws. Test the laws whenever there has been a violation. Working with another organization called Disability Rights Watch in Zambia, we've been taking cases to court just deliberately to test the law, so that we can be able to ensure that whenever the law is interpreted and it's brought. So even the judge here talked about that law on vagabonds and all that. That had the judgment in Zambia where we took to court to litigation on that one, and the judge struck out because in the 2019 Mental Health Act that had to be removed from our laws because of being colonial and sounding insulting to some of our citizens. So those are some of the strategic litigations we have done in that direction. And I mentioned about bringing the PSS together and the government ministers in charge of the various line ministries. And this is where I use the power of influence, which is vested in the office of the Member of Parliament. And since we work with the Speaker, we basically use that authority, being the third arm of government. So I think I'll let my colleagues come in. I think there are two other items, but let my colleagues come in, then we can also wrap up. Thank you so much.
Thank you so much. On the cases at regional level, we have what we call a reproductive justice litigation agenda at Afya na Haki. And in that agenda, we target litigations at national level, sub-regional level, regional level, and sometimes global level, where necessary. Why national level is important is that in many of the regional fora where we take cases, there are requirements of exhaustion of local remedies. You must go through the local courts structure, handle the issue, and then if they don't present the result you are looking for, if they don't give you a remedy or a solution to your issue, then you can transcend and go to either the sub-regional or regional court. That has been a challenge in strategic litigation because there are issues which you feel that at national level, you can't get a remedy in any court. Every judicial officer fears the case. Everyone fears the case because they may not get a promotion. They don't want to be on the bad side of the executive or the running government. Some of them might fear in that capacity to give you a remedy. So it has been a major challenge. But there are jurisdictions like West Africa, ECOWAS court, it has no such restrictions. We've supported a case there through our partner, where we are challenging, again, absence of safe abortion services for victims of sexual violence who are minors. It's also a very big issue in Nigeria. While we did not succeed on the evidential basis because they required us to present police reports, present follow-ups that we had with the given government agencies, which are not easy to access. But interestingly, the ECOWAS court judicial officers noted that the Federal Republic of Nigeria is obliged to implement the MAPRO protocol. That was the score. Because in another case, which you prepare very well and have evidence on your side, you easily have a precedent you rely on to make a case. So on that point, on that ground, in my view, strategic litigation is not about winning. It's about creating the change that you're looking for. In some cases, you don't get a positive decision on the top, but through the litigation process, you start harvesting outcomes, but also through the interpretation and the pronouncements made throughout the judgment, there are positive aspects that create the change. So that case, we did not succeed on the evidential ground, but we succeeded on the fact that the Federal Republic of Nigeria was to implement and ensure that it adheres to the MAPRO protocol when it comes to provision of sexual reproductive health services. So this is a very important decision, and you could use this decision even in lower courts at the state level in Nigeria to make a case and say, your government, federal government was directed to implement my protocol. So you cannot have laws which are against the protocol. You have to provide services directed for, provided for in the protocol. So I find that very important. Even ESC at the East African level, where you prove that whatever you're highlighting is in contravention of the treaty, the East African Community Treaty, you can highlight a case. SADC, Sanfina Tribunal, is no longer active, but it's a good forum to bring such cases because at a regional, sub-regional level, they have the experience to be able to handle litigations from different parameters, but unfortunately it's not active the way the South African Court of Justice and the ECOWAS Court are active. At the African Commission, again, there are also restrictions, especially on the exhaustion of remedies, local remedies. That's why there are a few cases that have been filed there. But as part of our agenda, this is on top of our agenda. In some litigation, especially like the ECOWAS court decision, some of the cases that we see at the national level, we have a big plan to see that we take them to the African Commission. Also, the African Court has also restrictions because your country must have signed a declaration recognizing the court. And many of our countries in East and Southern Africa are running away from that. even Tanzania, which is the secretariat, I don't have full information, but the last time I heard they were thinking about withdrawing their declaration because they fear being taken to that court. So many of our governments fear. So you have to take a government which has declared that recognizes the court. So there are some of the hurdles that we face, especially when it comes to engaging regional courts. But nonetheless, there are also special mechanisms at even the regional level. They have a special rapporteur on rights of women in Africa. If there are pertinent issues, for instance, in a particular country, A or B, which requires a direction from the African Union through the special rapporteur, you could either file an allegation letter or engage the special rapporteur to see that they direct the government either to investigate or even file a report on how far they have gone in terms of implementing a particular decision. But also we encourage all our partners across the region to see that they also participate in universal periodic reviews, because we found a very important process. It's at a UN level, but it's very critical. Because like for Zambia, in the latest for Zimbabwe, I think, the latest human rights report to the government of Zimbabwe, the Human Rights Committee recognized the judgment that I talked about earlier, and then commended the government of Zimbabwe for that step, yet it was civil society which took the case. But they were advised to expedite the amendment of the Termination of Privileges Act to integrate the judgment. So those mechanisms are also very, very important. They are complementary to the mainstream litigation. When we experienced the global gag rule, and many of the speakers in the first sessions were speaking about how the US directives have impacted on access, how the Kenyan government has committed 40%. I mean, over our countries are struggling to see that they fill the gap. We, together with the partners that we work with, filed an allegation letter to different special rapporteurs at the UN level, highlighting how the US government, through its directives, is impacting on reproductive justice or SRHR access in our countries. So we engaged the special rapporteur on right to health, Dr. T. I don't know if her mandate is almost expiring. The special rapporteur on torture, special rapporteur on freedom of assembly, and so many other things that come with the gag rule. So we've not yet heard from the special mechanism, but these are also very important legal procedures that we pursue to see that we create change, even with governments which are very strong as the US government, and they have been effective in some capacities. So I think that is it in terms of the regional approach to litigations. There was a question on the harm reduction model. The harm reduction model is a broad model from Latin America. They have used it to see that where there are restrictive legal frameworks, where the conservative judiciaries, my lord, sorry for using that, judiciaries which have to adhere to the pressure of the government or the community, and then they don't independently make decisions for the betterment of the vulnerable and the affected people. So it is a model that has been very, very important. So in countries which have restrictive frameworks, and I think this is common in most of our countries, so the harm reduction model helps to see that health practitioners, advocates, even lawyers frame cases which are within the existing legal frameworks. As Afi and Hakim used it in Senegal, because Senegal has total ban on abortion access. So we used it to see that we train providers, health service providers, on how they can continue providing services within the parameters of the existing legal framework, but also do advocacy. How do you do advocacy in such an environment? How do you package your messages? How do you document? Even in Uganda, it has been a very important model, especially where it comes to the penal code, which does not recognize medical abortion. So recognize surgical abortions. The people who are dispensing drugs to women to access termination services. So we'll be building legal defenses, harm reduction legal defenses for those different categories to see that they continue providing what within the parameters of the law. So this framework is very, very important, especially in environments which are very, very restrictive. I think lastly, for my part, in terms of some of the challenges that we faced, which are critical, is that you cannot link strategic litigation from legal support. Some of them some call it legal aid or pro bono support. It's very important because some of the big cases we've done that I've worked on have come from this legal support, the legal aid. There's a brother from Zambia who was talking about defilement cases that that have been in court for a long time. So legal support is very important. We receive these cases, we provide the legal support, but they help us to build strategic cases that create big change for a bigger community. So again, at Afya na Haki, we have a framework on legal support, which has different dimensions and different contexts that we work in. So legal support is important. If a woman is arrested for accessing a termination, or if an adolescent is arrested for seeking a services which we don't within the existing policy framework, they need to provide a free legal support. And this is very expensive in many countries. For instance, in Madagascar, one of our partners say that it's very, very expensive to hire a lawyer. But when you have a legal response framework or legal support services, women that cannot who cannot manage paying for legal fees to a very expensive lawyer or to a lawyer, they can also use that to be able to get free legal support and also get justice in their causes. So legal support is very, very, very important. Lastly, my Lord, I think you could hint on this, that we have different legal frameworks in Africa. We have the civil law system, especially majorly in the Francophone Africa, and also the common law system in common law Africa, or Anglophone Africa. Civil law countries apply the law the way it is. They don't have judicial activism. A judicial officer cannot go beyond the law to be able to use their judicial pen to create change. But in common law, we are likely that the judicial office can go beyond that, the existing legal frameworks, look into the circumstances of the case, and then provide justice to a particular client. So we've seen cases where pregnant girls have been denied termination, where a judge goes and says that provide care because you'll be embarrassed before their peers. This is not in any law, but because of the activism, they even go into social context of the particular person before them to make a case for their justice. I think that is it that I would be able to respond, and thank you so much for listening to us and giving us the audience. Thank you.
I'll try to be very fast. Firstly, I have been to other prisons, but not before, not as a judge right now, but when I was working with the Ministry of Justice, I visited Zambia, can't remember where else, because I was doing a lot of prison work then. But in Malawi, I visited our prisons, including our children's centers. That's where we host our young ones. The number in Malawi I know is known for our young people who are in prisons, but we also differentiate. So you have the young, the youth, and whatever, but ages are disaggregated and that information is available. The concept of accessing services within the prison system or the rehabilitation system, it always depends on, one, the finances, two, the personnel that are there. If they do have the necessary health personnel, most times they don't. So they rely on civil society that work in prisons. That's why this work that we're doing with prison oversight is actually interested in the concept of health as part of the prison oversight issues, because health is one of the most neglected areas in prison services, because they're not meant to do health as a whole, but it's part of the system, and it's something that must be inculcated and ingrained in the system. So yes, it's always difficult, but it has to be part of the model law, but also part of our policies, part of the legislation in country. Now, on the question is, how do you ensure laws align with reality? The issue that she's busy. I'm a legislative draftsperson. She asked this question. I'm a legislative draftsperson. The biggest concept about reality is whose reality, who's drafting, and from what perspective are they drafting from? It's a lot of issues to look at. And that's one of the reasons why, as draftspersons or persons that work in the drafting section, to always look at the regulatory impact assessments. Now, regulatory impact assessments require you that you look at the evidence that requires that law to come into existence. What is the law? What is the evidence saying that we should be legislating on? How should we legislate? For what reason? To what parameter? I say this because when it comes to parliament, I'm sorry, parliamentarians also have their own subjective and issues. They also legislate sometimes from their own morality perspective. A law could have come with a particular issues that Minister of Health has looked at it and has said, this is what is needed. Minister of Justice has gone and reviewed it and said, this is what is needed. Cabinet has approved and said, this is what it goes to. But parliamentarians would now start also putting in their own perspective. Now that's where the accountability that people have also with their parliamentarians, because they're there to represent the people's views. They're elected as people's representatives. Now the question is, have they gone back to their constituency to check if their views and their people's view align? So those are the parameters that when you look at legislation, that's why it's necessary to always ensure that consultation is effective, the regulator impact assessments are done, and also the people that need to be in the spaces are in that space. I'll give you an example of one very fundamental issue that we had. When we were passing the HIV/AIDS Prevention and Management Act, that act, when it was being drafted, has so many problematic laws, to the extent that when it was Minister of Justice Cabinet was being told all the time, you can't pass this because of A, B, C, and D. It's too broad. It's too this. The most affected people will be women, because women are the first ones to know their HIV status. They know it because they get pregnant. When they get pregnant, it's mandatory for you to get tested. Whether you're married or not married, whether you're young or old, you will get tested if you're pregnant. So we said, when it talks about transmission, exposure, and all that, women will be the most victimized. It wasn't being heard. To the extent that we even had parliamentarians, we brought them in. Parliamentarians understood us, but the draftsperson was still refusing to remove it. We had to put in a strategy that said, how do we get our parliamentarians to actually understand this? The judges, there's a judges, Africa judges panel that works on HIV. It had spoken. I was approached as being part of the system to say, look, we're going to ask women living with HIV to be at Parliament on the day that the legislation is going to be passed. What do they need to look out for? We had a whole day session where we sat with these women. There are about 30 of them from across Malawi. We said, you must speak to each and every legislator who comes in and say, if you make me go to jail, I will decampaign you. Sorry to say. But literally, it was, and also making them understand what it meant if that law is passed. So they went to say, I am your constituents. Why are you not listening to me? Why do you want me to be criminally liable? They are asking the member of parliament. Every member of parliament that walked in was asked that question. To that extent, those provisions don't exist in the HIV Prevention and Management Bill now, because the advocacy went beyond just, on the day of passing the bill, we said, you need to be present because you are the one most affected. So you also must look at who's most affected by the law and how they get their voice heard in that system. The final one, I was asked, how do I balance? It's always interesting. Sometimes they call me an activist judge. But this is my fundamental principle. I took one simple oath, that is to protect the Constitution and to do so without fear or favor. That's my fundamental basis. And the Constitution has one basic principle: the rule of law, human rights, and constitutionality. Everything that I do is based on that, including any work outside it, because there's nothing in the work that we do that says you cannot do this work, because it's part of bringing the courts closer to the people. People must understand what the courts are there for. That is to access justice. That is to make you recognize what the laws are and how they affect you. So this is how I will always answer people. I said, this is what it is. But as he had indicated, one of the fundamental principles that we're lucky as a common law jurisdiction, and especially human rights-based institutions or constitutionally set countries, is the fact that judicial activism is allowed in our constitution. If you look at the way we interpret, it says you can interpret based on all these parameters. But the fundamental also aspect of law is that there must be justice, fairness, equity. Now, all those parameters also require the concept of activism, because sometimes equity might not look at the justice of issues. Fairness might not look at the justice of issues, because the justice says go this way, but fairness for an issue will say go that way. And that is what judges must do when they have cases before them. And that is all within the ambit of the Constitution and the oath that we take to uphold. So I will always say this, that as long as nobody can question that I fulfilled my constitutional duty, then yes, there will always be issues of human rights promotion and protection, and also the promotion of the rule of law, which is what we are set to do. So that is one of the reasons why I always say, I'm able to say we can be very hypocritical as people. I look at the fact that as culturally, as in within Africa, we so much believe in initiations. And these initiations used to teach young girls and young boys sex issues. Yet now, when you want to teach sexuality, for them to understand the rights and the obligations and the responsibilities, we now keep saying, oh, culture says this. But yet, culturally, we've been teaching children about sex from so long ago. We've been marrying children from so long ago. Even in the system where you find a health service provider refuses a child access to a service, yet if she comes, even if she's 16 and says I'm married, she's automatically given that right, which is discriminatory, because marriage is now being used as a distinction for getting service, while the unmarried 16-year-old won't get it. So it is a parameter that I think sometimes we need to interrogate, and we need to put it out there and say, let's be honest with our traditional leaders, our cultural leaders, ourselves, about what are the hypocritical issues that we are putting out there, yet we know in reality, culturally, socially, it's different. Thank you.
Sorry, there was I think an issue on the same development which the gentleman Mike asked about, and I guess he was talking from the point of view of the girls who have been defined, hopefully. Yeah, I just wanted to comment before, then you can answer it. I think it would be good, actually, if we got more details. Then we have also another organization, one or two organizations which we work with. I think we also, the Women in Law, and another one in Zambia, where we are working on these kinds of cases on the children that are in conflict with the law, and so that we can maybe pick it up and take it forward in that manner. So I think it requires more information. So you can go ahead.
I think you can also tell him when he comes back that when you look at the judiciary has also mechanisms for how you push a case through. So if the magistrate or judge is not available, the registrars or the chief magistrates or the chief justice's office can be contacted and talked about and said, look, these are the parameters we're looking at. There's a delay. You can sometimes even ask for a change of a judge or a magistrate, or sometimes you can even directly ask the magistrate, since you seem to be uncomfortable. I've been asked several times where I thought that I wouldn't give justice, I would recuse myself. So there's that possibility. But he asked a very pertinent question, is how do we reduce actually sexual assault? The problem, I go back to the very nature of culture and whatever. There's so much we accept within culture against children, the kind of violence against children. There's certain aspects that we accept. I'll tell you, or if you go do prison oversights, we have an old age wing in our prisons, all our prisons. If you ever ask those people, what are they in for, the men, you'll find that 3/4 of them are in for sexual assault of children. It's either children that is their own grandchildren, because most times their parents would have left children with their grandparents or stuff. So there is an intrinsic element that we also need to cultivate as culturally, of protection of children. Who are we leaving children with? Because one of the fundamental things we have is we don't check the homes that we're leaving our children in. Our social welfare are so thinned out that they don't check for children in need of protection. And you find that children in those kind of homes are usually molested, either by the caretaker, which is usually a grandparent or an uncle within that space, or if that's not the case, they are molested outside because of care. So we need to also look at that. I want to give one fundamental issue that we've looked at in terms of helping reduce sexual offenses cases. This is something we do a lot, which is what Women Judges Association started, mobile courts. Mobile courts are a major advocacy and lobbying tool and a change agent. If you have a mobile court of 10 sexual offenses cases in the vicinity of where the offense took place, the case happens in that space, it concludes in that space, and the person is sentenced in that space. When you take a synopsis of people when they go out and ask them, what did that case do to you? They'll tell you one fundamental thing: I never want to do that because I'll go to prison for 40 years. Because right now our sentencing is around 40, 30, about 50 years for sexual offenses. So when you ask people around there, which meant, so when we took a synopsis, some of those areas where we used to have a lot of sexual offenses cases, there was a reduction because people could see justice being done. It was done in a speedily manner. So within a year or two, it was concluded. It didn't take any more than that. So the concept of having mobile courts or justice happening in the area where the crime took place actually helps in changing mindsets.
Thank you. Then the question on the, my brother here talked about the SADC tribunal. So I've asked that we get more information. Maybe my friends from SADC office, we can actually look into that matter to see what action can be taken, maybe to revive the tribunal. If it was helpful in the region, then it's something which should be an important body for the SADC Parliamentary Forum to take forward together with the PAP. Thank you so much.
Since my colleagues have made closing remarks, allow me to say a word. So the litigation is not a one-day event. It requires a lot of financial support, and many donors are not willing to support it because it's not like advocacy where you say, I want to do a media engagement tomorrow. You assemble media, you present your case, they do media stories on TV, radio, and you say, I've finished my project. So it requires commitment from different fronts. You do a lot of rigorous research, build evidence, prepare people, prepare teams, assemble strategies, advocacy, communication, train lawyers. Because I people think that if you are from law school, you can do strategic case on SRHR. It's not automatic. They require training. They require continuous capacity enhancement to see that they present, one, they appreciate the issues, but they present issues from the knowledge point of view. Otherwise, so many cases fail because they are rushed. 2, people are not prepared. 3, they want to tick off. So we need to explore as a strategy, but it requires preparation, it requires investment, it requires commitment, it requires a collaborative approach with different partners. You cannot move alone as lawyers. You need advocacy groups, you need communication groups, but also you need the community behind you. So the court of public opinion is very, very important when it comes to these cases. Thank you so much.
Thank you.
Okay, thank you so much. And you guys are tired, but the good news is we are done for the day. So let's just give our panelists another powerful round of applause as they leave the stage.
Let me ask 2 questions to give the books out. One question is which that's for non-Zimbabweans. This one. Which year did Bob Marley sing the song "Africa May Liberate Zimbabwe"? This question goes to non-Zimbabweans. I see Tatenda's hand is up. Non-Zimbabweans.